What we do now, because it's in 9 out of 10 cases, we're going to get an RFE, a request for evidence from the Citizenship and Immigration Service on an I-140 petition, which is the second step in the process. It's going to ask, please explain the ability of the employer to be able to pay the federally mandated prevailing wage. So what we'll do is, rather than to make assessments later on, or to make assumptions, which later on can be bad assumptions, what we try to do is we try to pre-screen the employer to make sure that the employer does in fact have the ability
up front. When the client comes for that, I ask that question: who is the employer, what is the kind of job, and what is the financial position?
Is it financially stable employer or not? Very important to do it up front.
Because remember, David, this kind of case, employment third preference may take 5, 6, 7 years or more.
Well, so or second preference, it could be a master's or its equivalent.
But the EB3, then we have to tell the employer that they would need at the time that the I-140 is to be filed. Correct. Immigration will say, give us tax returns of every year from the time that the labor certification is filed until you are filing the I-140 petition.
Correct.
So if they know all that, and they agree on that, then it's a good case.
Now, the next level of analysis would go something like this. We would take a look at the individual's resume, and then we would make sure that they actually have the experiences that they say that they have, because that's something else that gets a little delicate, because we have to be very careful to ensure that we're not asking for experience that the individual does not have.
Let me tell you an interesting question. A lady came from Gujarat, Gujarati lady, and she was applying as a cook in an Indian restaurant here, and some other lawyer had done a labor certification. In his experience, he said, cooking this meat, beef curry, this and that. I said, beef curry? A Gujarati Hindu woman in Gujarat making a beef curry? I mean, the officer will say, what is this nonsense? So they will immediately doubt and challenge and do the investigation and deny the case. So basically, it's very, very important that a case has to be properly prepared. You have to talk, understand what the experience is, how that experience relates to the job offered, employer's ability to pay. All those questions you have to go into before you start the case.
Right. So you're saying that a vegetable curry would have worked, but a meat curry is going to be a problem.
Right.
And you're absolutely right, Michael. I mean, that type of focus is so critical when you do a labor certification
also,
case.
You got a brother who's a U.S. citizen, and he says, we kind of file a petition. Yes, but you are looking at about maybe 9, 10 or 12 years.
Long time.
So long time. But same thing happened in the previous EB3 case also. The question is here, labor certification is approved. He files an I-140, that's approved. But then he can adjust if he is a 245I. But even in the I-140 form, we have to be very careful that all the documentation are properly filed. However, a small question that comes sometimes. Does the filing of I-140 by an illegal alien, employer is filing, but the information is there is not legally there. Can that trigger an arrest of the alien?
Well, I think what you're asking is, can a labor certification filing on behalf of an illegal alien?
Maybe that also, and maybe I-140.
It's a great question. We get that question all the time. And in fact, it's a very interesting one, because it goes to also the different sides of what's going on in the labor certification process.
Department of Labor.
Exactly.
The question is, will the Labor Department inform the immigration?
Share the information. There actually is a memorandum that goes back several years, where there is an informal discussion among the government agencies that they will not share this information. However, that was many years ago, and now the databases have become much better. And I think that there may be a viability that this information could at some point be shared. Maybe, yeah. I mean, I always say it this way to our clients, is that there's a difference between what's called possibility versus probability.
Yes.
There's always a possibility that something will happen. But what is the probability is another question altogether.
Exactly.
So the likelihood or the probability here is very low. But there is always a possibility that looms out there.
Okay. The last question probably is the 10-year rule. I know what he means by 10-year rule. He's talking about suspension of removal. If the person has not been placed in deportation proceeding, and he has been here for over 10 years, and there are equities, he got a citizen children,
and has good moral character,
and good moral character, then an application can be filed before an immigration judge for suspension of removal, and if the judge grants that, the person can get a green card. However, I try to explain to the people that in Hindi, let me say some Urdu with your permission. "Aa bail mujhe maar." What that means? He's telling the bull to come and kill me. In other words, he's voluntary, he has to go. He has never been deportation. He's going to go to immigration service, request, "Can you please put me in deportation so that I can apply for a suspension of removal?" I think it's a dangerous situation. I don't tell people don't do it until you get caught. See, if you are already placed in deportation proceedings, another thing I say, marta kya nahi karta, means but he's been arrested, he's in proceedings, he's dying anyway. So then what is the harm? Just go and file it. If you are eligible, you must try, have a good lawyer who can prepare a good application, forceful application, and if the judge grants that, you and the whole family will get the green cards.
Right.
So you have to be very careful in that.
Exactly. I'm going to say something in Hindi too. Mangala, mangala, mangala.
Mangalam.
It's good advice.
Yes, good
it's
advice.
excellent
Mangala.
advice. And in fact, that's exactly what we
And
tell our
maybe
clients
if we
too.
have another half a minute or a minute more, political asylum, you cannot, after you are staying here 10 years illegally in the US, you cannot go and apply for political asylum. It's not going to work. The rule is that you must apply for political asylum within 1 year from the date of your entry. Of course, there are some extraordinary circumstances under which you can probably apply late, but as a general rule, it's not going to fly, basically, to political asylum. So that's not a very good idea. But people that come in immediately and they have really a situation that they can apply for a political asylum at that time, there's something to consider in the initial 1 year period,
Right.
not after that.
Right, and there are exceptions to that 1 year rule, Michael. And
Except
we
in
look
the
at them
USA,
they're very limited and they're very restrictive, but in certain circumstances you can use an exception to
But
that
see,
1 year
there's
rule.
a danger also. Even those people who apply within 1 year, you have to understand, you apply for political asylum, if it's denied, almost certain that they are going to put you in proceedings and you can end up with a deportation order if they deny the political asylum. Be careful. These things like applying for a political asylum, applying for suspension of removal under this 10-year rule are to be carefully considered to see what are the chances of getting done, what are the consequences of denial of these things.
Right, and any filing that you make potentially brings you to the, brings you into the scope of an investigation. So you have to be careful to make sure that the filing you make is accurate, and in fact that it's not going to hurt you.
I think we did mention about the moving of the American consulate in Mumbai
Yes,
in
we
the last
did.
program.
Yep.
Just another reminder is that Mumbai consulate is moving from Bula Bhai Desai Road, already moved by the time that you are listening to this program, and now it is located in Bandra Kurla complex. And you should go on the website of the consulate. All the information is there before you are applying for anything and doing anything.
I'm also going to make one last point, and that is the H-1B visas are quickly running out. We probably are very close to the 65,000 cap on bachelor's or its U.S. equivalent. So if you haven't applied for the H-1Bs, please look into it as quickly as possible.
Thank you very much, Mr. Nachman. When you are going to be here
Michael.
many more times going forward. And the viewers, thank you very much for listening to the program. Please keep watching our program on TV Asia every Saturday at 1 p.m. Thank you.
When writing your questions to us, please let us know the city and state and how you're watching TV Asia. Dish, satellite or cable. If cable, the name of the company and the channel number. Thank you.